frequently I'll receive calls from clients who are landlords trying to evict a tenant for various reasons. Under such circumstances, it really depends on what the violations are by the tenant that determine how to proceed and how long it will take. In circumstances where a tenant is not paying their rent, you just proceed right to court and seek to evict. But if the tenant is in violation of some type of other provision in their lease, or if there's a noise violation, those types of activities, or they're violating like a parking restriction or something like that, you need to serve what's called a cease and desist order on the client first, advising them of the violation, advising them to correct it, and that further violations will proceed in you seeking to evict them from the premises. Those type of notices need to be served on the client. You can serve them by process, or you can have them served via regular and certified mail. In some circumstances where the violations are so severe, let's say where there is you have a damage to the property or personal injuries, what we would do is in that case the law does not have you warn the tenant. It allows you to serve a notice to quit and demand for the premises, and it give them 3 days to vacate the property, and at that time you are permitted to then file to evict the tenant. In circumstances where there's a late payment of rent, you have to have an ongoing pattern of late payment that you are monthly giving them a warning on before you can go to court and have them evicted. But in any circumstance where you have a problem tenant, the first thing you should do is call an experienced landlord attorney, understand what your obligations are as a landlord, and make sure that you're following all the requirements by law so that you can promptly and quickly resolve the situation and, if necessary, evict the client.